Morning, and let me thank all of you for this press briefing and all of my colleagues in the civil rights leadership in this country. We've called this so you will hear from major civil rights organization heads on our concern and our collective calling on the Senate not to confirm Judge Barrett to the Supreme Court. They will outline why each of the organizations have taken a position. Certainly, the hijacking of this from the 2016 procedures that they used in not having a sitting president who had nominated a Supreme Court justice or who had nominated a judge to be a Supreme Court justice in the person of Judge Garland, and their rationale being that you should not do so in an election year. That vacancy came about because of the death of Justice Scalia. And Justice Scalia died in February 14th of that year, Valentine's Day. And there was no voting going on. And there was no primaries yet that had, most of the primaries had not even taken place. Some, just a few had. And they used that to stall until a new president came in. They've taken the exact opposite position this occasion to nominate Judge Barrett, who has a record of clearly being against Roe versus Wade, against the Affordable Care Act, against voting rights and police reform, which is a major concern to the civil rights community. So it is important as they start their deliberations, finished her testimony yesterday, that the collective civil rights leadership be clear to the public the danger to the Affordable Care Act, the danger to voting rights, the danger to civil rights, the danger to women's right to choose, that this selection process is taking place, and that the public ought to go to their senators in each state and say, vote no on Judge Barrett. You will hear first from Damon Hewitt, who's the Executive Vice President of the Lawyers Committee on Civil Rights under the law, then from Derrick Johnson, who's the President and CEO of the NAACP, our oldest, largest civil rights organization. Then Melanie Campbell, the President and CEO of the National Coalition of Black Civic Participation. Then Mark Morial, who's the President, CEO of the National Urban League. And then Sherilyn Ifill, who has done a lot of work in this area, who is the President and Director Counsel of the NAACP Legal Defense and Education Fund. And then I'll make a closing statement, and we will then take 15 minutes of Q&A if any of the media wants. I'm asking all of our principals to try to stay to 5 to 6 minutes so we can hear everybody and have time for the Q&A. Let's start with you, Damon.
Morning, everyone. Thank you, Reverend Sharpton, for convening us. Thank you to colleagues, leaders in the civil rights, social justice, racial justice space, leaders of this country, quite frankly, at a time when that leadership is critically needed. Just want to offer some framing remarks and then talk a bit about this nominee's record. First, just look at what we've come to. Look at how low the bar is. Many have said Judge Barrett is, competent. Some have said well qualified in terms of basic legal acumen. But the point is, we should not have to trade basic competence, given as so many of the nominees to the lower court from this administration have been deemed unqualified. We should not have to trade basic competence for a commitment to settled principles of civil rights and racial justice. That simply should not be a trade-off. And let's be clear, if refusing to answer questions, a nominee refusing to answer questions, even artfully so is maybe a great political move, but it doesn't give us any real insights into what will happen over the decades that this nominee would be on the highest court in the land with a lifetime appointment. Now, we do have, from even her narrow record, from a prior jurisprudence and a scholarship, we do see some things that concern us. And quite frankly, I wonder at times whether we're in a parallel universe. And let me tell you what I mean by that. First, as Reverend Sharpton mentioned, we had Judge Merrick Garland, who was nominated by President Obama, didn't even get a hearing, no consideration at all, several months before an election. But here, in the middle of a pandemic, while the Senate's technically in recess, and while an election is not coming, the election is actually underway right now. Several million people have already cast their ballots and voted. We actually have this nominee on a fast track to confirmation with a vote scheduled, essentially, we heard this morning, even before all the evidence is before the committee, even before her entire record has been revealed to the public. And we keep learning more and more every day, and everything that we hear is of concern. Now, there's a parallel universe here in another respect. So Judge Barrett and I have some things in common. We both grew up in the New Orleans area. We both were raised in the Catholic faith. We both attended Catholic schools. But somehow or another, our experiences or our takeaways diverge sharply. Because, see, I know from the experience from the great city of New Orleans that Mark Morial led, from the state of Louisiana, as a son of the South, as a Black man in the United States of America, I understand that racism is real, it exists, and it impacts people's daily lives. But that's something that Judge Barrett, in her jurisprudence certainly, and in her evasive responses to questions, seems not to acknowledge whatsoever. Now, I don't understand how you can come from a place like Louisiana, the place that gave us Plessy versus Ferguson, right? A place in which people of African descent were enslaved, how you can have a takeaway that doesn't really acknowledge how racism operates in context. Now, in a heated exchange with Senator Harris, I believe just yesterday, Senator Kamala Harris, Judge Barrett, when pressed on the question of whether racial discrimination exists in voting, she was non-responsive. And then she eventually said that she was happy to acknowledge that racism exists, almost as if it's something out there in the ether, as if it's an abstract principle. So the problem with that, though, is racism is not an abstract principle. Racism literally has an impact on people every day, especially Black people. It is the literal barrier to opportunity and access. It's the thing that prevents the intergenerational transfer of accumulation of or transfer of wealth from one generation to the next. It's the reason why so many Black people are disproportionately harmed and are dying because of this COVID pandemic. It is, as Reverend Sharpton has said before, it is the knee on our necks. Racism operates in context, but this nominee seems to not understand that. And let's talk about her record in that regard. Voter intimidation. She's unwilling, when questioned by Senator Klobuchar, to acknowledge that not only that racial discrimination in voting is a problem, but that voter intimidation is illegal under current federal statutory frameworks and at the state level as well. When it comes to absentee ballots, she avoided the question, pretended as if it was a political move or political question, when in fact we know it's essential that there be wide and broad ballot access, because to do otherwise would constrict democracy and voice for Black Americans and all Americans. Employment discrimination, and one of her most chilling opinions that Judge Barrett has written in her narrow record in a case called Smith versus Illinois Department of Transportation, she essentially ruled that being called the N-word in your workplace by co-workers, even supervisors, does not constitute discrimination, racial discrimination, not clearly. And she wrote, while racial epithets may have made for a crude or unpleasant workplace, that the law imposes what she called no general civility code. She said that this particular Black employee had introduced no evidence that his colleague's use of the N-word changed his subjective experience of the workplace. Now, I know most Americans would understand, pretty much anyone of conscience would understand, being called the N-word or any racial epithet or anything of that sort does change your experience. But to this nominee, it's as if discrimination, racism is in the abstract. It doesn't matter in terms of how people actually experience it. And so what that really amounts to, quite frankly, between the evasiveness, between what we know from the record, the jurisprudence, and also speeches, which I have not got into, which my colleagues may, it's almost as if her unwillingness to acknowledge what we know to be true in this moment of consciousness, of wokeness, so to speak, for America, it's almost essentially an erasure of the lived experience of Black people. Now, the tension between her judicial philosophy, her ideological philosophy, and people's daily experience is an untenable tension. And that is a tension that we would submit at the Lawyers Committee and throughout the civil rights community that is untenable. It is a tension that America should not tolerate. It's a tension that the Senate should not tolerate either. America deserves answers. America deserves clarity. America deserves a commitment to what it's bursting at the seams this summer in particular and going forward. What it's really asking for is a commitment to justice and clarity. And that's simply what we do not have for this nominee. And that is why the Lawyers Committee, several dozen members of our board, and so many in the civil rights community have come out against and recommended not confirming this nominee for the U.S. Supreme Court. Thank you, Reverend Sharpton and colleagues.
Thank you, Damon. Derrick Johnson, President and CEO of the NAACP.
Thank you, Reverend Sharpton, and good morning to my colleagues in the civil rights community. Never in history in this country has the Senate considered a Supreme Court nomination during the middle of a presidential election. And yet we are here with over 16 million people who have already voted to date. The president has refused to commit to a peaceful transfer of power. He has told the American people he wants Amy Coney Barrett in a seat on the Supreme Court to decide the election in his favor. The Barrett nomination is illegitimate in our opinion, and it is corrupt based on the president's statement alone. Instead of forcing a nomination into the highest court, the Senate should be addressing the harms this global pandemic is raging across this country and disproportionately impacting African Americans and Latinos. 217,000 Americans have died as a result of this global pandemic, and the staggering proportion have been Black and brown. Our communities are jobless and our economic system is in crisis because we are looking at a national problem without a federal response, and yet the Senate is seeking to address an appointment on the Supreme Court during a time we have never seen before. In a normal world, the Senate would rigorously examine a Supreme Court nomination, but not here. Yet, you had senators pledging to confirm someone before the nominee was even named. Once Amy Coney Barrett was nominated, they suspended the rules to move her through the process at lightning speed. Today, the Judiciary Committee listed her for a vote before her hearings is even over. That's not what you do for a lifetime appointment to the Supreme Court. Then you have a record. This is someone who models herself as Justice Scalia, after Justice Scalia's, who called the Voting Rights Act a racial entitlement. This is someone who said only virtuous citizens should have the right to vote. This is someone who refuses at her hearing to answer whether vote suppression still exists, whether intimidation is illegal, and whether the president could use his authority to deny the right to vote based on race. Amy Coney Barrett would leave no stone unturned in rolling back our rights. Her aggressive views of when past decisions should be overruled, combined with her reactionary positions on what rights the Constitution protects, would jeopardize our hard-fought wins in the court to date. She questions even the fundamental principles, such as whether the 14th Amendment was properly adopted, which was shocking to us to say the least, and whether Brown versus Board of Education remain a viable authority. She says it's good law because it won't be challenged. But what if it is? There are over 30 Trump judges who have refused to say Brown versus Board of Education is correctly decided. If precedents are challenged, she says it's her job to follow the Constitution. If she believes if the precedent is in conflict. Within that construct, that put Brown versus Board of Education in jeopardy. On issue after issue, we have found her incredibly hostile to civil rights. She has repeatedly endorsed discrimination in the workplace. This includes stunning conclusions that separate can be equal when it comes to race, that the use of racial epithets, as Damon just mentioned, does not necessarily create a hostile work environment, and that longstanding civil rights enforcement tools could be severely limited. She is clearly willing to cast aside longstanding civil rights precedent. The stakes could not be higher. The rights of African Americans to fully participate in this democracy and in every facet of social and economic life on an equal basis lie in the balance. NAACP, we have fought to protect the Supreme Court since 1930, when we helped defeat a nominee that Herbert Hoover put forward. We continue to fight to ensure that equal protection under the law is enforced and that the highest court in the land is one that is balanced and respect that our lives, that Black lives truly matter. But at the same time that this nomination process is going on, we encourage all African Americans to vote like we have never voted before. This is a clear example that elections have consequences. And if we want to realize the democracy that we all expect to have, we must participate at levels in which we would not allow this to exist again. It's important for us to stand in unison as a civil rights community to speak to this moment, because it is in this moment that we will find an impact that will last for decades. Thank you, Reverend Sharpton, for pulling together this press conference as we all fight for democracy and to ensure that our rights are respected and our rights are protected.
Thank you, Derrick. Now we will hear from Melanie Campbell, President, CEO of National Coalition of Black Civic Participation.
Thank you, Reverend Sharpton, and thank you to all my colleagues. The National Coalition on Black Civic Participation, Black Women's Roundtable, we truly believe that Judge Barrett was put there for several reasons. One, to protect the current president in case he loses at the ballot box on November 3rd. Two, to reverse the Affordable Care Act, to strike it down, to continue to damage our rights when it comes to voting rights, and to reverse Roe v. Wade. So we don't, we, along with many of my colleagues here, do not believe that she should be confirmed. One of the core things that, as we all are sitting here today, folks are voting all over this country. We believe that Judge Barrett will do all she can, if she's put on that bench, to just continue voter intimidation as a matter of course. When Judge Barrett would not commit to giving a definitive answer about addressing voter intimidation, one of her responses, I can't characterize the facts in a hypothetical situation, and I can't apply the law to a hypothetical set of facts. I can only decide cases as they come to me, litigated by parties on a full record. This is very troubling because we know Brnovich versus Democratic National Committee is a major voting rights case that is coming up Supreme Court docket and could be heard January or February of 2021. So we believe that the issues that I've laid out and others from my colleagues that have already been stated should be a reason. And lastly, just remembering what happened during the Obama administration when Mayor Garland would not even get a hearing and President Obama put him up for Supreme Court in February. We're 20 days away from the election. And what the Senate is doing, the leadership of the Senate is doing, is really just turning its head on what this democracy is all about. And so with that, Reverend Sharpton, I turn it over. And again, we believe that the American people are voting. One last thing I would say, Reverend Sharpton, is we released a poll with the Black Women's Roundtable in Essence, and Black women are really, really concerned about the Supreme Court. The top issues of concern for Black women that came out of that poll, racism and hate crimes, the issues around voting rights, criminal justice reform, and policing reform, very, very high on the list. And the Supreme Court, 63% of Black women see this as a major concern. So as Black women and Black folks are going to the polls, we're paying attention to what's going on in the Senate right now, and we're voting with, and we're speaking with our vote.
Thank you, Melanie. Mark Muriel, President, CEO of the National Urban League.
Let me take this opportunity to thank you, Reverend Sharpton, for your leadership in pulling us together this morning. I also want to thank all of my civil rights colleagues for the eloquence and substance with which they've spoken this morning. And let me just add a few additional thoughts on behalf of the National Urban League. The Trump administration and Senate leadership have spent 4 years cramming and packing the federal courts with right-wing ideologues intent on eradicating hard-fought civil rights advancements. The confirmation of Amy Coney Barrett to the United States Supreme Court will mark the point of no return for the independence of the federal judiciary. Now, while some may say that Judge Barrett, on paper, is qualified by training and experience, she was nominated based on her willingness to limit or overturn the Affordable Care Act, limit or overturn civil rights and voting rights protections, limit or overturn reproductive freedoms enshrined in Roe versus Wade. Trump has said the quiet part out loud. He makes no secret that he expects the court to have a role in upcoming election lawsuits and decide those in his favor. He expects this Supreme Court to strike down the law that provides health care to millions and millions of Americans during this deadly pandemic. The absolute rush and haste to confirm Judge Barrett is part of a scheme to create a conservative supermajority on this Supreme Court that would overturn the will of the majority of Americans for many decades to come. What do Black people have to lose? What does America have to lose? Well, Monday's appalling ruling by a panel of Trump-appointed judges in Texas is a prime example of how rank partisanship has infected the federal court system. That court upheld the decision to allow just a single ballot collection site for each county in Texas, including only one for the 4.5 million people, or 4.5 million voters who are in Harris County, which is where Houston is located, and that's a landmass larger than the entire state of Rhode Island. If the Supreme Court sanctions this kind of political manipulation, there's simply no limits on the rampant voter suppression that we can expect in November and many, many years beyond. I believe that history will not look favorably on what this Senate leadership appears to be poised to do. And there's one last chance for them to honor their oath and the will of the American people, and that is to reject wholeheartedly and completely the nomination of Amy Coney Barrett. Thank you, Reverend Sharpton.
Thank you, Mark. Sherilyn Eichel, President and Director Counsel of the NAACP Legal Defense Fund.
Thank you, Reverend Sharpton. To be a civil rights lawyer is to suspend disbelief. You work in a system that you know is stacked against you, but you believe and you trust that if you are prepared, if you are excellent, if you have moved your case forward following the rules of our system, that you will have an opportunity to have your client's story heard, and that you will have an opportunity to vindicate the rights your clients hold under the Constitution. It's a delicate balance, but it's one that we were taught by the founder of the Legal Defense Fund, Thurgood Marshall, who founded our organization in 1940, when truly everything was stacked against us. But within 4 years, he had won one of his most important cases in the United States Supreme Court, a voter suppression case, Smith versus Allwright, ending the use of all-white primaries in the South. What we have seen over the last 3 years has pushed us to suspend disbelief even more. We have watched this president and the Senate Judiciary Committee and the Republican leadership in the Senate pack the courts with ideologues, with judges in some instances who have been deemed unqualified, and with a whites-only slate of judges who now sit on the circuit courts and the district courts around the country. We have watched the Republicans refuse to move forward President Obama's nomination of Merrick Garland, and then move forward after the presidential election, Neil Gorsuch. We watched the Republicans take unprecedented license with the rules of the Senate, the norms of the confirmation process, and the ethics of the process in moving forward Judge Kavanaugh to ensure that he took a seat on the Supreme Court. And now we come with 15 million votes cast in the general election, with 220,000 Americans dead of the COVID-19 pandemic, with nearly 9 million Americans infected with this terrible disease. We come in the midst of that pandemic. We come just 20 days before Election Day with this latest effort by this president and the Republicans to strain the integrity and legitimacy of our justice system. When Amy Coney Barrett was nominated, we took a very clear position that no nominee, whatever their qualifications, should be moved forward under these circumstances. Nevertheless, we did examine the record of this nominee and determined that she herself should be opposed for a seat on the Supreme Court. We recognized that the stakes were high for civil rights, that we have every reason to expect that core civil rights protections will be before the Supreme Court this term or in the coming years. They include affirmative action. The challenge to affirmative action at Harvard Law School is currently before the First Circuit Court of Appeals, even as we speak. LDF is a party in that case. We recognize that the Voting Rights Act, mortally wounded in 2013 in the Shelby County versus Holder case, will come back before the Supreme Court in a case out of Arizona that the court has agreed to hear this year. And if not through that case, then through subsequent cases, the court will have the opportunity to re-examine other portions of the Voting Rights Act, including the critical Section 2 provision that civil rights lawyers use to challenge discriminatory voting practices. We are well aware that we only have the disparate impact standard under the Fair Housing Act because of a 2015 decision decided 5-4 in the Supreme Court in a decision written by Justice Kennedy, who no longer sits on the court. Affirmative action, the Voting Rights Act, the Fair Housing Act, core civil rights protections that we can expect will be before the Supreme Court in the coming years. So we recognize that the stakes are high. We issued our report, we examined Judge Coney Barrett's record, we issued our report, and we expressed our concerns and misgivings, despite her very careful public statements, despite her careful writing, despite the fact that it was evident that she has long been groomed for this position, that gave us cause and concern. And what we have heard over the past 4 days has only confirmed and indeed deepened our concern about Coney Barrett. Let's take a moment to think about what we have heard over the past few days. We've heard Judge Coney Barrett refuse to commit to recusing herself from any case involving a contested presidential election, despite the fact that President Trump made clear his intention to fill this seat before the election because he believed it would be needed to decide a contested election case that would come before the Supreme Court. And his comments made clear that he expected that this nominee would be potentially a tiebreaker because so many on the right no longer believe that Justice Roberts is a guaranteed vote. And so President Trump said it would be terrible to have a 4-4 split. And so we need this seat to break the tie, clearly tainting this nominee and this process by suggesting that this person is expected to vote in his favor to continue his presidency. A clear case of the appearance of bias that taints this nomination. And yet Judge Coney Barrett refused to commit to recusing herself from any election case. It is worth reminding everyone that Judge Coney Barrett also worked as a young lawyer for George W. Bush's campaign in his contested election, working on issues involving the legality of absentee ballots in Bush versus Gore. We heard her refuse to unequivocally answer questions about the peaceful transfer of power, one of the cornerstones of any functioning legitimate democracy. She refused to affirmatively state that the president does not have the authority to change the date of the elections, when as a matter of law, he does not. She refused to state that the president does not have the power to pardon himself. She refused to admit that voter discrimination exists. And she seemed not to know that voter intimidation is a violation of federal law. With regard to precedent, she committed herself only to 6 cases that she regards as super precedent. One of those cases includes Brown versus Board of Education, but as you've already heard earlier, her commitment to Brown in her writing stems from her belief, as she says, that no one in their right mind would challenge Brown. And yet, as you heard from President Johnson earlier, 30 federal judicial nominees now confirmed to the federal courts have stated before the Senate Judiciary Committee that they could not say that Brown versus Board of Education was correctly decided. It would be crazy, she said, for someone to challenge Brown. But we live in crazy times. Finally, we must recognize the context in which this nomination comes forward. We've talked about the COVID-19 pandemic. When we talk about the COVID-19 pandemic as civil rights leaders, we have a very particular reason for addressing it. We know that the Black community has been disproportionately hit by COVID-19 infection and death. Just last night, a news story was released that revealed that almost all of the children in America who have died of the COVID-19 pandemic have been Black or Latino. We are talking about the lives of our children. We are also talking about the vitality of our communities. It has been predicted that 40% of Black-owned small business will not survive this pandemic. And so we waited and we pressed and we pushed for the Senate to take up COVID-19 relief legislation this summer. We all know that Black communities were less likely than others to be able to take advantage of the financial relief provided in the CARES package. And so the HEROES Act was created with an eye towards ensuring that the gaps that had been left would be filled. The HEROES Act passed the House on May 15th. And yet, even as we sit here today, as tens of thousands of Americans are in eviction proceedings, as millions more face the specter of evictions, as nearly half African-American owned small businesses face closure, as millions of Black adults and children face COVID-19 infection and potentially death, we are held hostage to a Republican Party in the Senate that is hell-bent on completing its power grab. And for that reason, we oppose this entire process. We oppose the confirmation of Amy Coney Barrett, and we oppose this challenge to the integrity of our legal system that has been unfolding over the past 3 years. Thank you, Reverend Sharpton.
Thank you. Before opening up for questions, just let me reiterate that you've heard from the CEOs and leaders of the major civil rights organizations of this country. Certainly with National Action Network and I agree with what has been said. It seems to me to be a strategic move by this president to try and act as though the issue is whether the opposing party to him is trying to pack the courts later, by and by when the morning comes, when he is literally trying to pack the courts now with anti-civil rights justices to vote down things that will be on this calendar, this session, that will affect and impact the lives of the people that we represent. I believe that people tell us a lot when they tell us the tradition they come from and their heroes. This president said very publicly that his hero as president was Andrew Jackson. He hung a picture of Andrew Jackson in his Oval Office. Andrew Jackson nominated to the Supreme Court Judge Roger Taney. Judge Roger Taney was the one who had the ruling of Dred Scott that blacks had no rights that anyone was bound to respect. If this is his hero, then I would assume that he was guided by the spirit of Andrew Jackson and whomever he nominates to the very Supreme Court that Jackson did. And that alone makes us feel that he is nominating some 21st century Judge Taneys that may be more polished, that may have more of a characteristics of being moderate and not as reactionary as he is in his personality, but will vote the same and disregard the rights of people that need health care, that need voting rights, that need to have policing accountable, that needs LGBTQ rights and women's right to choose. And that's why we come together in this unusual collective to call on the Senate to reject the process, the hijacking, and the nomination, and then confirmation of Judge Barrett. We'll open up, I will ask Ebony Riley, who has Washington Bureau of National Action Network, to help us conduct the question and answer for 15 minutes.
Thank you, Reverend Sharpton. If you're a member of the press, please identify yourself with your name and your media outlet, as well as who your question is posed for in the Q&A. And we have our first question. It is from Aaron Haynes, editor-at-large for the 19th, and the question is from Melanie Campbell and Sherilyn Eiffel. We'll now unmute you, Ms. Hayes, and please pose your question.
We don't hear Aaron.
Ms. Haynes, please unmute.
She's still muted.
Can you guys hear me now?
Yeah, don't worry, Aaron. They've been trying to mute me for 40 years.
Well, we know that's not going to happen, Reverend Sharpton. Listen, thank you for convening this conversation, and thank you so much for this perspective from everybody. My question, President Campbell, you mentioned that the Supreme Court is on the ballot for Black women, and we know that Black women are the majority of the Black electorate and are vulnerable in terms of public health, even without the pandemic, as well as vulnerable in the workplace and with access to housing. I'm wondering if you and Director Eiffel, but really whoever from their organization wants to speak directly to the threat that you see this nomination posing specifically to Black women and what's at stake for them if Amy Coney Barrett is confirmed.
Thank you, Aaron. Good to hear your voice. Let me just speak as a Black woman who has pre-existing conditions, right? I don't have to go far to talk about it in abstract. If they strike down ACA, that could affect me. It could affect so many people in my family, so many Black women. Americans, we over-index when it comes to disparities. With what's going on with COVID. I'm recovering from it myself on a personal level. So don't know what that looks like when it talks about what the healthcare options I will have, just from a personal perspective. But I do know that for Black women, and I mentioned it, Aaron, is 63% of Black women, and this poll was taken with Black Majority in Essence back before this nominee came up back in late August and early September. So it was on the minds of Black women. Many folks have said it, justice is on the ballot. The top issue for the last 3 years for Black women has been racism and hate crimes, the kind of overt things that we studied in school, things that our parents went through. It's more and more overt. White nationalism is a real thing. Folks are overt about their racism in this time. We talked about it, the issues of criminal justice reform, those kind of things. And then what about healthcare? They're on the minds of Black women. And because of the pandemic and how it's been totally mismanaged and the loss of life is something that the history books will look back and say, what in the world was going on in the United States of America to allow this many people to die unnecessarily under this rogue president? those are the kinds of concerns that Black women have. Issues around safety, survival are like top across generations. And that's why I say justice is on the ballot, and our data shows that's the case.
Hi, Erin, thanks. Let me say, because I think Melanie really comprehensively laid it out, but I want to be sure to talk about reproductive health, which is also a Black woman's issue. And if you heard Amy Coney Barrett, so first of all, let's be very clear. Amy Coney Barrett is clearly an anti-abortion nominee. It doesn't matter what she says sitting in that chair about precedent. We have seen her statements. We have seen her sign-ons to an ad and statement disparaging Roe versus Wade. We have seen her connections to an articulation of women's reproductive health that sounds like something out of the 1930s. Yesterday, when she testified, she refused to say that the Griswold versus Connecticut case was correctly decided. Griswold should be a case that no one would imagine challenging. It is a case involving the right of married couples to contraception. If people think that this is just about abortion, they are sadly mistaken. This area of reproductive rights and freedom is also about contraception. It is at its core about the ability of women to make their own decisions to control their bodies. And there is no group of women in this country who have had their bodies more controlled and managed and commodified than Black women. And so we take seriously any effort to restrict our ability to make health decisions, to make decisions about our reproductive rights and future. And on that score, this nominee is a disaster. Her anti-LGBTQ positions as well. There are Black gay women, as we know, many, and Black gay men as well, but who want the freedom to marry, who want the freedom to love who they want, who want the freedom to be free of employment discrimination, and so forth. So every one of these issues that I think people describe in certain ways that suggest they don't implicate women of color, they do. The LGBTQ issues implicate women of color, and the abortion issues implicate women of color. Amy Coney Barrett spoke 5 times, gave paid lectures before an organization, before a group that was supported and funded by an anti-LGBTQ organization that the Southern Poverty Law Center has listed as a hate group because of their stance on transgender rights, because of their stance on gay people's ability to marry. So we need to be very, very clear that these two are attacks on Black women.
Thank you, Beth.
Thank you. Are there any more questions? I don't see any in the queue, but I want to give you an opportunity to place that in the queue at this moment. For the press, please again, identify yourself by name and media outlet. If it's a live question, please let me know. If it's a question in the Q&A, please feel free to put it there now. If not, we will close shortly. There are no more questions.
All right, well, thank you.
Thank you, everyone.
Reverend Sharpton,
Thank you all.
all the colleagues. Y'all be blessed.
Thank you all. Thank you, Reverend Sharpton
Thank
and
you.
Ebony.
Good to see you.
Thanks
Thank you
all.
all.
Bye.